All rise. Veuillez vous lever. The International Criminal Tribunal for the former Yugoslavia is now in session. L'audience du Tribunal Penal International pour l'ex-Yougoslavie est ouverte. Please be seated.
Good afternoon, everybody. Madam Registrar, could you call the case, please?
Good afternoon, Your Honours. This is case number IT 08921A, the prosecutor versus Mićo Stanišić and Stojan Župljanin.
Okay, before we commence, I want to make sure that the parties can follow the proceedings in a language that they understand. I'll start with Mr. Stanišić. Mr. Stanišić, you heard my question?
Čujem I razumem. Hvala.
Okay.
And I hear and understand the proceedings. Thank you.
I thank you, Mr. Stanišić. Mr. Župljanin, same question.
I od mene isti odgovor, čujem dobro, hvala.
Answer from me also. I hear you very well. Thank you.
Thank you both. Can I now please proceed to have the appearances of the parties, starting with the prosecution?
Good afternoon, Your Honours. Laurel Big for the prosecution, joined by my colleagues Aditya Menon, Todd Schneider, Grace Harbour, and our case manager, Janet Stewart.
I thank you, Madam. Appearances for Mr. Stanišić.
Good afternoon, Your Honors.
Good afternoon.
Appearing for Mr. Stanišić today, myself, Slobodan Zečević, lead counsel, Mr. Stefan Burgonj, co-counsel, and our colleagues Isabel Martino, James Jackson, and Relja Radović. Thank you very much.
Thank you, Mr. Zečević. Defense for Mr. Župljanin.
Good afternoon, Your Honors. Dragan Krgović, Tatjana Čmerić, Christopher Gosnell, Chad Mer, I Milena Đudović, appearing for Župljanin defense.
Thank you. Pursuant to a scheduling order issued on 2nd June 2016, the Appeals Chamber today delivers its judgment in the case of the prosecutor versus Mićo Stanišić and Stojan Župljanin. I shall now read out a summary of the central findings of the Appeals Chamber. The summary does not constitute the official and authoritative judgment of the Appeals Chamber. The official judgment is rendered in writing and will be distributed to the parties at the close of this hearing. This case relates to events which took place in Bosnia and Herzegovina from at least the 1st of April 1992 to at least December 1992. Throughout this period, Mr. Stanišić was the Minister of the Ministry of Interior of the Republika Srpska. I will be referring as I go along to this as the RS MUP and RS for Republika Srpska. By virtue of this position, he was also a member of the government of the Republika Srpska, and Mr. Župljanin was the chief of the Regional Security Services Center, which I will refer to as the CSB. In addition, from at least the 5th of May 1992 until July 1992, Mr. Župljanin was a member of the Autonomous Region of Krajina Crisis Staff. I will at times refer to this as the ARC crisis stuff. When I further on will mention appellants, that means I am referring to both Mr. Župljanin and Mr. Stanišić. The trial chamber found that during the indictment period, serious crimes were committed in the 20 municipalities listed in the indictment, including the 8 municipalities in the autonomous region of Krajina. I will be referring to these as municipalities and ARC municipalities as I go along. And the trial chamber also found that these serious crimes affected thousands of victims. The trial chamber found that the appellants participated in a joint criminal enterprise with the objective to, quote, permanently remove Bosnian Muslims and Bosnian Croats from the territory of the planned Serbian state. I will be referring to this as the JCE. It also found that this objective was implemented through the crimes of deportation, other inhumane acts consisting of forcible transfer, and persecutions through underlying acts of forcible transfer and deportation as crimes against humanity. These I will be referring to as we go along as JCE 1 crimes. The trial chamber further found that it was foreseeable for Mr. Stanišić that persecutions as a crime against humanity, murder, torture, and cruel treatment as violations of the laws and customs or customs of war, as well as murder, torture, and inhumane acts as crimes against humanity, could be committed in the implementation of the JCE. These I will be referring to as we go along as Mr. Stanisić's JCE 3 crimes. The trial chamber found that it was foreseeable to Mr. Župljanin that the same crimes and extermination as a crime against humanity could be committed. I will refer to these collectively as Mr. Župljanin's JCE 3 crimes. The trial chamber convicted the appellants pursuant to the first category of JCE for persecutions through forcible transfer and deportation as a crime against humanity. It convicted them pursuant to the third category of joint criminal enterprise for persecutions through several underlying acts as a crime against humanity, and for murder and torture as violations of the law or customs of war. In addition, Mr. Župljanin was convicted pursuant to the third category of JCE for extermination and for ordering persecutions through plunder of property. The trial chamber also found the appellants responsible for murder, torture, inhumane acts, deportation and inhumane acts consisting in forcible transfer as crimes against humanity, and cruel treatment as a violation of the laws or customs of war, but did not enter convictions for these crimes on the basis of the principles relating to cumulative convictions. The appellants were both sentenced to 22 years of imprisonment. Mr. Stanišić raises 16 grounds of appeal, while Mr. Župljanin raises 6 grounds of appeal. Prosecution, as I said, has also appealed and raises 2 grounds of appeal. The appeals chamber heard oral submissions by the parties on 16th December 2015. I will now summarize the Appeals Chamber findings on the appellants and the prosecution's appeals, addressing first the submissions made by the appellants in relation to fair trial. Mr. Stanišić, in his ground of appeal 1 bis, and Mr. Župljanin, in his 6th ground of appeal, submit that the right to a fair trial by an independent and impartial tribunal or court was violated as a result of the participation of Judge Frederik Harhoff in the trial proceedings, which they argue invalidates their convictions. The Appeals Chamber finds that contrary to the appellant's submissions, Judge Harhoff's disqualification in the Šešelj case does not automatically disqualify him from other cases, and that the appellants have failed to demonstrate that a reasonable observer, properly informed of all the relevant circumstances, would reasonably apprehend bias on the part of Judge Harhoff in this case. Accordingly, the appellants have failed to rebut the presumption of impartiality and failed to firmly establish a reasonable appearance of bias on the part of Judge Harhoff. Mr. Stanisić's ground of appeal 1 bis and Mr. Župljanin's 6th ground of appeal are therefore dismissed. Before moving to the Appeals Chamber findings on the remaining challenges by the appellants, I note that the Appeals Chamber considers that this section of the trial chamber dedicated to the conclusion on the appellant's responsibility, the trial chamber did not provide cross-references to earlier findings or citations to the evidence on the record. The trial chamber considers that this approach is regrettable, as it has greatly convoluted and increased the exercise of identifying underlying findings and analysis for the parties and the Appeals Chamber alike. I'll deal now with the aspects of common purpose within the framework of joint criminal enterprise. Mr. Stanišić, under his 3rd ground of appeal in part, and Mr. Župljanin, under his 1st ground of appeal in part, submit that the trial chamber erred in law in defining the common criminal purpose of the joint criminal enterprise, in particular by conflating the legitimate political goal for Serbs to live in one state with the criminal objective of the joint criminal enterprise. The Appeals Chamber finds that the trial chamber clearly determined that there existed a common purpose amounting to or involving the commission of crimes provided for in the statute of the tribunal. The appellants have thus failed to demonstrate that the trial chamber erred in defining the common criminal purpose of the joint criminal enterprise. And so Mr. Stanisić's 3rd ground of appeal in part and Mr. Župljanin's 1st ground of appeal in part are therefore dismissed. I'm going to deal briefly with the aspect of membership in the joint criminal enterprise. Mr. Stanišić, in his 2nd ground of appeal, and Mr. Župljanin, in his 1st ground of appeal in part, raise several challenges to the trial chamber's findings in relation to the membership of the joint criminal enterprise. In particular, Mr. Stanišić submits that the trial chamber erroneously equated being part of the Bosnian Serb leadership with membership of the JCE. The appeals chamber finds that there is absolutely no basis for this argument, and that the appellants have failed to show that the trial chamber erred in its findings in relation to the membership of the JCE. The appeals chamber thus dismisses Mr. Stanisic's second ground of appeal in its entirety and Mr. Župljanin's first ground of appeal in part. I now turn to Mr. Stanisic's ground of appeal relating to his participation in the joint criminal enterprise. Under his seventh ground of appeal, Mr. Stanišić submits that the trial chamber erred in law and in fact by not according full probative value to his voluntary interview with the prosecution conducted between the 16th and the 21st of July 2007, and by failing to grasp the trust of the information provided. The appeals chamber finds that Mr. Stanišić has failed to demonstrate that the trial chamber ventured outside the scope of its discretion in weighing and assessing the evidence in the light of the entire trial record, and that therefore it erred in its assessment of the interview. Accordingly, Mr. Stanisic's seventh ground of appeal is being dismissed. Under his first and fifth ground of appeal in part, Mr. Stanišić submits that the trial chamber erred in law by failing to set out and apply the correct legal standard for contribution to a joint criminal enterprise through failure to act, and that consequently it erred by finding that he contributed to the JCE. The appeals chamber finds that the trial chamber applied the correct legal standard and dismisses Mr. Stanisic's first and fifth grounds of appeal in part. Under his first, fifth, and sixth grounds of appeal in part, Mr. Stanišić submits that the trial chamber erred by failing to provide a reasoned opinion when it failed to pronounce on whether the military or civilian authorities were responsible for the investigation and prosecution of crimes against non-Serbs committed by policemen resubordinated to the military. The appeals chamber finds that Mr. Stanišić has not demonstrated that the pronouncement on whether military or civilian authorities were responsible for the investigation and prosecution of crimes committed by resubordinated policemen is a factual finding that was essential to the determination of his guilt, the lack of which would result in a failure to provide a reasoned opinion. The appeals chamber therefore dismisses Mr. Stanisic's first, fifth, and sixth grounds of appeal in part. Under his first and sixth grounds of appeal in part, Mr. Stanišić argues that the trial chamber made no findings as to whether and how he contributed to the JCE and whether his purported contribution was significant, thereby failing to provide a reasoned opinion. In his fifth and sixth ground of appeal in part, Mr. Stanišić further alleges numerous factual errors in the trial chamber's assessment of his contribution to the JCE. With respect to the latter, the appeals chamber first finds that the trial chamber erred by considering the appointments of Stevan Todorovic, chief of Bosanski Samac Public Security Station, and Kristosavic, Chief of the Trebinje CSB, as Mr. Stanisic's direct appointments of JCE members to the Republika Srpska MUP. Second, the appeals chamber finds that the trial chamber erred by concluding that Mr. Stanisic failed to take decisive action with respect to the Luka detention camp. The appeals chamber dismisses the remainder of his arguments alleging factual errors in the trial chamber's assessment of his contribution of the JCE. With regard to the alleged failure to provide a reasoned opinion, the appeals chamber agrees with Mr. Stanisic. It finds that the trial chamber's failure to enter express findings as to whether and how Mr. Stanisic's acts and conduct furthered the JCE and whether his contribution was significant constitutes a failure to provide a reasoned opinion. Therefore, the trial chamber committed an error of law. This error allows the appeals chamber to assess the trial chamber's findings and relevant evidence concerning Mr. Stanisic's acts and conduct to determine whether a reasonable trier of fact could have concluded beyond reasonable doubt that he significantly contributed to the joint criminal enterprise. For reasons set out in the judgment, the appeals chamber concludes that the trial chamber's findings, with the exception of overturned findings referenced above, as well as the evidence relied upon, support a finding that a reasonable trier of fact could have concluded beyond reasonable doubt that Mr. Stanisic significantly contributed to the JCE. On the basis of this foregoing, the appeals chamber dismisses Mr. Stanisic's first, fifth, and sixth ground of appeal in part. I will address the appeals chamber findings on the impact of the factual errors of Mr. Stanisic's sentence later in the summary. Under his first and third ground of appeal in part and fourth ground of appeal, Mr. Stanisic submits that the trial chamber erred in finding that he possessed the requisite intent for liability under the first category of joint criminal enterprise and raises several legal and factual challenges in this regard, including a challenge as to whether the trial chamber provided a reasoned opinion. With respect to the alleged error by failing to provide a reasoned opinion, the appeals chamber regrettably notes again the trial chamber's approach not to provide cross-references to earlier findings or citations to the evidence on the record. Moreover, it notes that with respect to a number of factors on which it relied to conclude that Mr. Stanisic possessed the requisite intent, the trial chamber adopted vague, generic, and nondescript terms to refer to factual findings in other section of the trial judgment. This approach is problematic, and as already stated, it has complicated the appeals chamber's review of the trial chamber's reasoning. Nonetheless, the appeals chamber considers that through a careful and thorough examination of the trial judgment, the trial chamber's reasoning is discernible. Therefore, the appeals chamber concludes that ultimately the trial chamber did not fail to provide a reasoned opinion for concluding that he possessed the requisite intent and therefore dismisses Mr. Stanisic's argument in this regard. The appeals chamber finds that the trial chamber committed two distinct factual errors in assessing Mr. Stanisić's knowledge of crimes. Namely, first, the trial chamber erred by finding on the basis of the communications logbook of the Republika Srpska MUP headquarters and the Sarajevo CSB from 22nd April 1992 to 2nd January 1993, that Mr. Stanišić was, quote, regularly informed through 1992 about crimes, unquote. Second, the trial chamber erred in finding that on 18th April 1992, he was informed that a certain Joka had arrested Muslims in Sokolaj. In addition, the appeals chamber finds that the trial chamber erred in fact in finding that Mr. Stanišić was a member of the Bosnian Serb Assembly when assessing his intent. Mr. Stanisić's remaining arguments with respect to his intent are dismissed. On the basis of the remaining upheld findings of the trial chamber, the appeals chamber finds that the aforementioned errors do not, however, impact the trial chamber's conclusion on Mr. Stanisić's intent. The appeals chamber therefore finds that Mr. Stanišić has failed to demonstrate that the trial chamber erred in finding that he possessed the requisite intent for the first category of joint criminal enterprise liability throughout the indictment period, namely from at least 1st April 1992 until 31st December 1992. For these reasons, the appeals chamber dismisses Mr. Stanisić's first and third ground of appeal in part and his fourth ground of appeal in its entirety. I now move to Mr. Stanisić's challenges concerning his conviction pursuant to the third category of JCE, in particular his first ground of appeal in part and his 8th to 11th grounds of appeal. In his 8th ground of appeal, Mr. Stanišić submits that the trial chamber erred in law by entering convictions for the specific intent crime of persecutions as a crime against humanity pursuant to the third category of joint criminal enterprise. The appeals chamber finds that Mr. Stanišić has failed to show that cogent reasons exist to depart from its well-established case law allowing for such convictions. It dismisses Mr. Stanisić's 8th ground of appeal. In his first ground of appeal in part and his 9th ground of appeal, Mr. Stanišić argues that the trial chamber failed to make the required findings on the subjective element of the third category of JCE in relation to the following crimes. First, murder as a crime against humanity and as a violation of the laws or customs of war. Second, torture as a crime against humanity and as a violation of the laws and customs of war. Third, cruel treatment as a violation of the laws or customs of war. And lastly, inhumane acts as a crime against humanity. The appeals chamber is of the view that the trial chamber made the required findings. Therefore, Mr. Stanisić's first ground of appeal in part and 9th ground of appeal in its entirety are being dismissed. In his first ground of appeal in part and his 10th and 11th ground of appeal, Mr. Stanisić further alleges several errors with respect to, first, whether his JCE 3 crimes were natural and foreseeable consequences of the joint criminal enterprise. Second, whether his JCE 3 crimes were foreseeable to him, including whether the trial chamber provided a reasoned opinion for its conclusion in this regard. and third, whether he willingly took the risk that they might be committed. The appeals chamber finds that Mr. Stanišić has failed to show an error in the trial chamber's findings. As such, the appeals chamber dismisses his first ground of appeal in part and his 10th and 11th grounds of appeal in the entirety. I am now going to turn to Mr. Župljanin's ground of appeal relating to his participation in the joint criminal enterprise. I will first address Mr. Župljanin's first ground of appeal in part, challenging the trial chamber's findings in relation to his responsibility pursuant to the first category of joint criminal enterprise. Mr. Župljanin alleges legal and factual errors in relation to the trial chamber's reliance on his failures to act, in particular his failure to launch criminal investigations, to discipline his subordinates, and to protect the non-Serb population, in concluding that he significantly contributed to the joint criminal enterprise and that he possessed the intent to further this JCE. The appeals chamber rejects Mr. Župljanin's argument that the trial chamber erred in law by failing to apply the correct legal standard when it considered instances of his failure to act to determine whether he contributed to the JCE and had the requisite intent. In addition, the appeals chamber finds that Mr. Župljanin has not demonstrated that the trial chamber erred by failing to make findings that he had sufficient control or authority over the police as a result of declining to pronounce on issues of resubordination of the police to the military. The appeals chamber also dismisses Mr. Župljanin's remaining arguments in relation to the trial chamber's findings on the aforementioned failures to act on his part. Consequently, the appeals chamber finds that Mr. Župljanin has failed to demonstrate that the trial chamber erred in relying on these failures to act to infer his contribution to the JCE and his intent. Furthermore, Mr. Župljanin raises challenges in relation to the trial chamber's findings on his knowledge of and role in the unlawful arrests and detention of non-Serbs in the ARC municipalities. The appeals chamber finds that Mr. Župljanin has failed to demonstrate that the trial chamber erred in concluding that the arrests and the detentions of non-Serbs in the ARC municipalities were unlawful, and that the trial chamber erred in relying on his knowledge of and role in the unlawful arrests and detention to establish his contribution to the joint criminal enterprise and his intent. Mr. Župljanin also argues that the trial chamber erred in relying on several of his other positive acts to conclude that he significantly contributed to the joint criminal enterprise and or that he had possessed the requisite intent. The appeals chamber finds that the trial chamber erred in finding that Mr. Župljanin was present at the Serbian Democratic Party main board meeting at the Holiday Inn in Sarajevo on 14th February 1992. I'll be referring to this as the Holiday Inn meeting. And in relying on his on this factor when assessing his intent to further the joint criminal enterprise. Mr. Župljanin's remaining arguments concerning his other positive acts are dismissed. I now turn to Mr. Župljanin's challenges to the trial chamber's overall approach in finding that he significantly contributed to the joint criminal enterprise. The appeals chamber dismisses Mr. Župljanin's arguments in this respect, moreover recalling that he has not shown any error in relation to the trial chamber's reliance on the factors relevant to his significant contribution. The appeals chamber finds that he has not shown that no reasonable trier of fact could have found that he significantly contributed to the joint criminal enterprise. Mr. Župljanin further raises challenges to the trial chamber's overall approach in finding that he shared the requisite intent under the first category of joint criminal enterprise. The appeals chamber dismisses Mr. Župljanin's argument in this respect, and in particular finds that he has failed to demonstrate that the trial chamber applied an incorrect standard for the subjective element of the first category of joint criminal enterprise. Moreover, while the appeals chamber has found that the trial chamber erred in relying on Mr. Župljanin's purported attendance at the Holiday Inn meeting, he has failed to show that the trial chamber's conclusion that he possessed the requisite intent during the indictment period would not stand on the basis of the remaining factors. Consequently, the appeals chamber finds that Mr. Župljanin has failed to demonstrate that no reasonable trier of fact could have found that he possessed the requisite intent pursuant to the first category of joint criminal enterprise. In the light of the foregoing, the appeals chamber dismisses Mr. Župljanin's first ground of appeal in part. In his second ground of appeal, Mr. Župljanin alleges various errors of law and fact concerning his convictions pursuant to the third category of joint criminal enterprise in general, including that the trial chamber erred in failing to make specific findings that he possessed the intent to participate in and further the common purpose of the joint criminal enterprise by finding him liable pursuant to the third category of JCE for crimes of greater gravity, in quotes, than the JCE 1 crimes. He further raises arguments with respect as to whether his JCE 3 crimes were natural and foreseeable consequences of the joint criminal enterprise, and the trial chamber's findings that his JCE 3 crimes were foreseeable to him and he willingly took the risk that they might be committed. For the reasons set out in its judgment, the appeals chamber is not persuaded by Mr. Župljanin's arguments and dismisses his second ground of appeal in its entirety. In his third ground of appeal, Mr. Župljanin challenges his conviction pursuant to the third category of joint criminal enterprise for extermination as a crime against humanity. The appeals chamber is not convinced by Mr. Župljanin's submission that the trial chamber erred in finding that the actus reus of extermination was met in relation to certain incidents. The appeals chamber further finds proprio motu that the trial chamber erred in law by failing to make a clear finding on whether the principal perpetrators of the incident in which 20 detainees died during the transportation from Betonirka detention camp in Sanski Most to Manjača detention camp in Banja Luka municipality possessed the required mens rea of extermination. This constitutes a failure to provide a reasoned opinion. However, following an assessment of the relevant evidence and factual findings, the appeals chamber concludes that a reasonable trier of fact could have found beyond reasonable doubt that the perpetrators acted with the required mens rea. Therefore, the trial chamber's error does not invalidate the trial judgment. Mr. Župljanin also argues that the trial chamber erred in finding that extermination was foreseeable to him. The appeals chamber agrees that the trial chamber erred in relying on certain evidence to find that Mr. Župljanin knew on the Sanski Most incident. However, it finds that despite this error, a reasonable trier of fact could have found that Mr. Župljanin was informed of the incident shortly after it occurred and relied on this knowledge to find that extermination was foreseeable to Mr. Župljanin and that he willingly took and continued to take the risk that extermination could be committed. The appeals chamber rejects all remaining arguments advanced by Mr. Župljanin in this ground of appeal and therefore dismisses his third ground of appeal in its entirety. Mr. Župljanin's conviction for ordering persecutions through plunder of property. This is what I'm going to deal with now. Under his fifth ground of appeal, Mr. Župljanin challenges the trial chamber's findings that he ordered persecutions through plunder of property through his order of 31st July 1992. For the reasons set out in its written judgment, the appeals chamber finds that Mr. Župljanin has failed to demonstrate an error on the part of the trial chamber and dismisses his fifth ground of appeal in its entirety. I'll deal now briefly with the aspect of cumulative convictions. In its second ground of appeal, the prosecution submits that the trial chamber erred in law by failing to enter convictions for the crimes of murder, torture, deportation, and other inhumane acts consisting of forcible transfer as crimes against humanity, in addition to the convictions it entered for the crime of persecutions as a crime against humanity through the same underlying acts. Recalling the well-established jurisprudence that convictions for the crime of persecutions and other crimes against humanity based on the same conduct are permissibly cumulative, the appeals chamber finds that the trial chambers committed an error of law when it failed to enter convictions for the crimes of murder, torture, deportation, and other inhumane acts as crimes against humanity. Accordingly, the appeals chamber grants the prosecution's second ground of appeal. However, for reasons you will find set out in the judgment, the appeals chamber declines to enter new convictions on appeal. I now come to the crucial part of this summarized judgment, turning to sentencing. The appellants and the prosecution have each appealed the sentences of 22 years of imprisonment imposed by the trial chamber. Mr. Stanišić in his 12th through 15th grounds of appeal, and Mr. Župljanin in his 4th ground of appeal allege a number of errors of law and fact in relation to their sentence, including with respect to the trial chamber's consideration of the gravity of their conduct, aggravating factors and mitigating factors. They also allege that the trial chamber erred by double counting certain factors. The prosecution submits in its first ground of appeal that the trial chamber erred by imposing manifestly inadequate sentences on the appellants. the appeals chamber finds that it has not been shown that the trial chamber committed a discernible error and therefore dismisses the grounds of appeal raised by the appellants and the prosecution in relation to sentencing in their entirety. I now come to this position. Mr. Stanišić and Mr. Župljanin, will you please rise? For the foregoing reasons, the appeals chamber, pursuant to Article 25 of the statute and rules 117 and 118 of the rules of evidence and procedure, noting the respective written submissions of the parties and the arguments they presented at the appeal hearing on 16th December 2015, sitting in open session, dismisses Mićo Stanišić's appeal in its entirety, dismisses Stojan Župljanin's appeal in its entirety, affirms Mićo Stanišić's conviction under counts 1, 4, and 6, and Stojan Župljanin's conviction under counts 1, 2, 4, and 6, grants the prosecution's second ground of appeal and finds that the trial chamber erred by finding that convictions for the crime of persecutions as a crime against humanity under Article 5 of the statute are impermissibly cumulative with convictions for other crimes against humanity based on the same conduct, and also erred by failing to enter convictions for Mićo Stanišić and Stojan Župljanin pursuant to Article 7(1) of the statute under counts 3, 5, 9, and 10, but declines to enter new convictions against Mićo Stanišić and Stojan Župljanin on appeal under these counts. Dismisses the prosecution's appeal in all other respects, affirms the sentences of 22 years of imprisonment imposed by the trial chamber against Mićo Stanišić and Stojan Župljanin respectively, subject to credit being given under Rule 101C of the rules for the periods of time they have already spent in detention. Rules that this judgment shall be enforced immediately pursuant to Rule 118 of the rules of evidence and procedure of this tribunal, and orders in accordance with Rule 103C and Rule 107 of the rules that Mićo Stanišić and Stojan Župljanin are to remain in the custody of the tribunal pending the finalization of arrangements for their transfer to the state where their sentence will be served. Judge Liu Dashun appends a declaration. Judge Kofi Kumelio Afande appends a separate opinion. Mr. Stanišić and Mr. Župljanin, you may now be seated. That brings me to the end. Before adjourning, I would like to express my sincere thanks to everyone in this courtroom present today and in the past during the hearing that we have had. And also I would like to thank those outside this courtroom who constitute quite a group for all the assistance that they have provided during these proceedings. And in this case, I'd like to thank the interpreters. I'd like to thank the recorder, the registrar, the entire staff. Most of all, I would like to thank two groups of persons in particular. One is the team that assisted us, the judges, in preparing this judgment. They have all worked hard, round the clock, many a time, 7 days a week. And I would like to commend them publicly, and I will also like to thank my esteemed colleagues sitting with me today for their complete cooperation in a case which was conducted at quite a speed when everyone is really busy with several other matters in this tribunal. I thank you for your cooperation, because without it we would not be here today. So I'll now conclude this hearing. The appeals chamber stands adjourned. But before we leave the courtroom, may I remind you, Madam Registrar, we spoke on this outside before we entered the courtroom. You're now please asked to distribute a copy of the judgment to the parties. Thank you.
All rise. We will leave it.